Good afternoon, everyone. My name is Jack Klug, and I'm a senior member on the Tulane Maritime Law Journal. My comment is entitled, Exploring a Seaman's Right to Maintenance and Cure for Injuries that Manifest After Employment. A seaman's right to maintenance and cure has been recognized for centuries in admiralty law. The shipowner must give maintenance and cure to a seaman for an injury that occurred, manifested itself, or was aggravated while the seaman was in the service of the ship. Most of the time, the analysis is simple. The seaman gets injured, and the shipowner must pay maintenance and cure. Nevertheless, the analysis becomes more unclear when determining whether maintenance and cure should be available when a seaman's injury manifests itself while he's not in the service of the ship, and it is unclear when the injury or illness occurred or whether it aggravated his condition. My comment explores these gray areas. The seaman may be cut off from maintenance and cure benefits depending on when an injury or illness occurs. The range of illness or injuries for which a seaman can recover maintenance and cure is expansive. It ranges from lung disease to back injuries to emotional injuries, as well as pre-existing injuries. The question my comment addresses is whether maintenance and cure is available for injuries or illnesses that first manifest themselves after employment. The obligation to provide maintenance and cure payment does not furnish the seaman with the source of lifetime or long-term disability insurance. Still, the Supreme Court requests liberality in interpreting this duty for the benefit and protection of the seaman. Payment seemingly will be barred for injuries and illnesses that manifest after employment, but the analysis is not that simple. Some case law suggests that seaman may be able to receive maintenance and cure for injuries that develop after employment. Many illnesses and injuries are known for not manifesting immediately. Oftentimes, an injury or illness is associated with delayed symptoms that may first appear weeks after the incident occurs. Some of these illnesses and injuries that may take a while to reveal themselves include whiplash, post-traumatic stress syndrome, cancer, and concussions. Specifically, pancreatic cancer is an injury that takes a while to manifest itself. In 2010, Johns Hopkins produced a study that stated after the first pancreatic cancer cell appears, it will take nearly 7 years for that cell to multiply into a tumor the size of a plum. In 2008, the United States Court of Appeals for the Ninth Circuit consolidated in a single appeal 174 separate actions from seamen claiming to have been exposed to asbestos. Asbestosis is another common disease that takes a long time to appear, sometimes 10 to 40 years. In the aforementioned case, each seaman claimed to have been exposed to asbestos in the course of the employment on the vessels. However, none of the seamen had been diagnosed with any asbestos-related diseases. The Ninth Circuit did not award them cure because it ruled that they needed to be presently sick or injured in order to recover. However, the court's decision suggests seamen would be able to recover if they were to show that they were sick even after employment. Even though a seaman may argue that his illness or injury occurred while in the service of the ship owner may say that the seaman is not able to establish when and where the affliction occurred. The seaman does not have to prove causation, but timing. That is, he must demonstrate that the illness for which he seeks maintenance and cure began or was aggravated while he was in the service of the ship. The seaman seeking maintenance and cure damages for any injury or illness that first manifested after employment often will find it difficult to prove that the particular affliction began or was aggravated while he was in the service of the ship. The seaman may recover maintenance and cure for a pre-existing illness that was aggravated while the seaman was in the service of the ship. In Messier v. Bouchard Transportation, the Second Circuit used an occurrence rule and opined that a seaman is entitled to maintenance and cure for any injury or illness that occurs or becomes aggravated while he's in the service of the ship. In that case, the court ruled that the seaman could receive maintenance and cure for lymphoma that was not known to the employer or the employee during his employment. The court stated that it was undisputed that he had lymphoma during his employment and the disease did not manifest itself after he was in the service of the ship. In its analysis, the court in Messier highlights other decisions where seaman cannot prove his injury occurred or was aggravated during his service. For instance, the United States District Court for the Southern District of New York in Browns v. Moore McCormick Lines denied maintenance and cure for a seaman's psychic trauma that manifested prior to service and reoccurred after service. The court ultimately concluded the seaman could not recover maintenance and cure without proof that the trauma occurred or was aggravated during the seaman's service. In line with the Messier Court's decision, a seaman should receive maintenance and cure for injuries that occurred during employment. Along those lines, a seaman will not receive maintenance and cure for injuries that happen after employment, not in the service of the ship, and he should not recover for injuries or illnesses that occurred before employment but are not aggravated during it. However, illnesses like asbestosis result in ambiguous occurrence and manifestation periods. It is often difficult to determine when the illness occurred, was aggravated, or manifested itself. In addition, questions surface as to how to define when a disease like asbestosis occurs or manifests. Does it occur when the disease is at its beginning or when the patient is diagnosed? Ultimately, any disputes concerning maintenance and cure amounts should be settled in the seaman's favor. Whether an occurrence or manifestation rule is used, courts should consider the nature of the illness more and use a totality of the circumstances analysis. A seaman in most circumstances will have a general idea of when he was injured. However, a court should still consider the specific injury and facts when determining whether to avoid maintenance and cure. Likewise, courts should focus on the type of illness and the seaman's specific circumstances surrounding that illness with respect to maintenance and cure. Some illnesses lend themselves to unclear manifestation and occurrence periods. When a seaman seeks maintenance and cure for such an illness, the court should examine the illness itself and the facts specific to the seaman's specific case. Consequently, courts should use the totality of the circumstances analysis when looking at maintenance and cure. Of course, using an occurrence rule could lead to complicated litigation. In addition, an occurrence rule does not adequately protect the seaman when it is unclear when the disease occurred or when it was aggravated while he was in the service of the ship. Proponents of an occurrence rule will say that if it is not used, more and more seamen will try to recover maintenance and cure after employment was terminated. However, a focus on the type of injury and the totality of the circumstances will address both of these concerns and adequately protect the seaman. It will be interesting to see how courts handle more cases when a disease or injury does not necessarily have a clear manifestation period like asbestosis. Courts have analyzed the ins and outs of the pre-existing illness scenario. Nevertheless, not much analysis is focused on the availability of maintenance and cure after employment, where the illness or injury does not naturally have a clear manifestation period. Additionally, a majority of courts have not focused enough on the type of injury when considering whether to award maintenance and cure. Nevertheless, many illnesses and injuries require that sort of analysis. These afflictions have uncertain manifestation and occurrence periods, so courts should use an occurrence-based rule to award maintenance and cure. The doctrine of maintenance and cure should adapt to what our society learns each day about healthcare with the help of today's innovations in medical technology. As highlighted previously, any disputes concerning maintenance and cure should be settled in the seaman's favor. Thus, medical research on illnesses and injuries that are common in the maritime industry should be considered in maintenance and cure analyses. Ultimately, these maintenance and cure analyses should not only zero in on the type of injury, but also the totality of the circumstances. Thanks, everyone.